I want to turn now to Jennifer Crumbley, who took the stand in her own defense today, David. What do we think about that? Are things going well for her? How did she do on the stand? Did she help herself?
I think that as it stands right now, Michael, I'll give her a B, okay? But guess what? Tomorrow is going to be the cross-examination. For anybody that is on the defense side, when you call your client, you know it's going to be a cakewalk moving through that direct, right? The direct is easy because the defense attorney had time to prepare. She seemed very scripted. And that's going to show when the cross-examination comes, because a good cross-examiner that knows how to do it the right way is going to get those answers going yes, 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 through leading questions. And then she can't really be scripted as she was today. But so far, so good for her. I mean, look, the diary entries that we saw, wow. Yeah. The fact that Ethan Crumbley said that he was trying to get help and the parents prevented him from getting help, if believed, that could be really one of the best pieces of evidence that the state could present, if believed.
Yeah. You know, David, that's interesting because I see that a little differently, but a lot of folks online, they see it because the school wasn't insistent. There wasn't a disciplinary action taken. The things that they saw, the conversations they had with him, didn't lead them, the experts, to believe that he was a threat to the school, someone that had to be separated. They wanted him to go home with mom and dad, but they didn't insist on it. But also, while people say, yes, school had a problem, they still are not willing to absolve the parents of their responsibility.
Yeah, I think that's really what I'm seeing too in all these comments, is the fact that even if the school, they didn't do what they were supposed to do, the parents are the ones, they're the guardians, they're the ones that have custody, they're the ones that are required, really, right? But Michael, I don't want to end this segment without talking about that attorney-client issue at the end of the day. I mean, it could be possible that they've opened up the door to some attorney-client privileged communications because flight is at issue. And then the defense attorney says at the end, well, let's just strike that testimony. Let's bring the jury back in and strike. It doesn't happen like that, unfortunately. You don't just get to strike that. When you open the door, you could open the door to some communications that might prove that flight.
I know, I couldn't believe that she actually said that. I mean, you can't put the genie back in the bottle. Once the testimony's out there and you've opened the door, well, you've opened the door. The judge is not going to say, okay, you made a mistake, let's go back and tell the jury to not consider it. It did. You know, quickly, David, there's a myth out there that prosecutors aren't good cross-examiners. You're a former prosecutor, now you're a defense attorney. Is that fair? Because we're anticipating a rough cross-examination. We've seen a lot here on Court TV that it hasn't quite worked out that way.
No, it's absolutely fair. Look, this trial advocacy, this skill that we have as trial attorneys, it only comes with experience. You cannot watch Court TV and just get that skill. You can't just watch people in the courtroom. And for prosecutors, when they put on their cases, they're limited to open-ended questions. They can't lead in the way that defense attorneys do. That's why defense attorneys are so much better at cross-examination, because they have the skills, they have the experience. That's the way they ask questions. So and defendants, they don't typically take the stand too. I mean, it's rare that a prosecutor gets an opportunity to cross-examine. So without that experience, it's hard to get those skills, and that's why we see prosecutors typically aren't that very good at cross-examination.
Yeah, we're all waiting to see what happens tomorrow on the stand, as Jennifer Crumbley is set to take the stand again tomorrow on cross-examination. We'll bring it to you here, every moment of it, on Court TV. All right, we're going to take a break. It is time now for today's Talkback segment. Each day we post a question on Court TV's social media pages. We gather your comments and questions, respond right here on the show. Today, the defendant testified in the school shooter mom trial. Prosecutors are accusing Jennifer Crumbley of failing to exercise reasonable care to prevent her son from carrying out the Oxford school shooting in 2021. So we wanted to know, how did you think she did today on the stand? Still with me to discuss, Deputy Chief of Investigations from Gwinnett County, Georgia, Curtis Clemens, and criminal defense attorney, former prosecutor David Bruno. All right, gentlemen, our first comment comes from Nancy. Nancy says, I swear this mother is painting a perfect TV family show. Sorry, I don't believe nothing out of her mouth. He tried to clean his room. A teenager should clean his own room. Curtis, let me start with you. I thought her testimony was helpful. I thought she needed to take the stand to put context to a few things that were really standing out. I thought she did that, but again, like this viewer said, she seemed practiced, and it just didn't come across as authentic to me.
Yeah, I think her testimony attempted to whitewash what was really going on in the home. As a parent myself, when you have a child claiming to see demons and things moving around the room, that is a huge red flag and a clue that you need to get that child some help.
Yeah, no doubt about it. All right, our next comment comes from CK. CK says, I've lost count of how many times Jennifer referred to her son's everyday behavior as awful. He was awful about homework. He was awful about cleaning his room. No praise. I kind of agree. I understand kind of what she meant. You know, if you have teenagers, you kind of get what she's saying. Things start happening around 15, 16 years old, and they just become kind of awful. And it's just because they're defiant and they're figuring out who they are, and that kind of comes out as defiance and whatnot. But at the end of the day, she said something on the stand which I found interesting. When asked by her attorney if she would have done anything different, she said no. And while it didn't come across well, I understood, David, why she had to say that, because she couldn't say, hey, I would have changed if I paid more attention to him, or I would have changed it that day, I would have brought him home. Any of those things hurts her case.
Without a doubt, it'd be pretty much an admission, right, Michael. I mean, and that's what you bring. That's the risk that you have when you call the defendant to the stand. I mean, you know that question's coming. In fact, the question was asked by the defense attorney, which is probably going to tee up the cross-examination for tomorrow. But with respect to the comment, I mean, that's relatively common commentary by a parent, unfortunately, you know, but it doesn't end right there. I mean, she said just messing around, just messing around. She's attributing this troubling conduct to just messing around, which is one thing, but then couple it with the guns in the household and the access to guns and the shooting the guns. When you have both of those together, that's where her biggest problem is going to be. And that's where I would go after the cross-examination right there, is everything that she knew, I'll be going right out again, line by line, just messing around with the guns.
Yeah.
That's where her weakness is going to be tomorrow, and that's where I think the prosecutor is going to focus.
Yeah, I think the guns might supply that foreseeability that we all see as might being a little bit of a problem. Our next comment comes from Sandy. Sandy says, I can't wait for the cross. They need to really go after her. She seems like she has no remorse. And you know what's interesting, Curtis? I agree. She doesn't come across as warm and fuzzy on any level. And, you know, obviously her defense attorney made a decision to put her on the stand. As I said, I think it was necessary. But that's problematic because, again, you're judging her. And even though she may have remorse, she just doesn't seem like a very warm and fuzzy person.
No, I saw the same thing. There appears to be no remorse on the stand, no acknowledgement that, you know, maybe, like you said before, maybe I should have been more keen to these signs that I was seeing. Everything was just kind of blasé, you know, with her in her testimony, just no remorse whatsoever.
Yeah, David, quickly on the foreseeability issue. Do you think just the fact that they introduced guns into the situation, is that somewhere where the prosecution can hang their hat for this foreseeability?
It's going to have to be the prosecutor's theory of the case. I mean, let's not forget, this is the first time that this prosecution is happening for a parent of a shooter, right? So it's proof beyond a reasonable doubt in a criminal context. That's where they have to go. And the flatness without remorse is going to be the thing maybe that pushes it over into the guilty verdict. And that's unfortunate because she wasn't the shooter in the case, but her flat effect is going to be troubling.
Yeah, they're gonna judge her. Once you put her on the stand, it really becomes all about her. All right, Curtis Clemens, David Bruno, thank you so much for joining me today on the show. Real pleasure.